This is case number 2007-0447. Harold Lassonde III, DBA Mountain View Construction versus Charles Stanton et al.
Counsel, before we begin, I want to announce that Justice Duggan will participate in this case by listening to the tape.
Thank you.
You're free to proceed.
May it please the court, I'm Joshua Gordon. I represent Chuck and Susan Stanton. My opponent wants to paint the Stantons as unreasonable, but in the context of the circumstances they faced, they acted reasonably. We have a contract here that doesn't bar oral modifications and plenty of oral promises during its execution regarding timing, upgrades of materials, and particular tasks. Some of the promises concern changes to items contained in the written contract and some not in the written contract. Some of the oral promises were grand, some small, some were performed, some not. But the Stantons had no way to know which oral promises the Lassondes intended to perform or which they regarded as mere puffery. How, for instance, is Stanton supposed to distinguish between Lassonde's promises to move the shower, which was done, or help with the generator, which was sort of done, or I'll take care of everything, which was clearly not done? As Chuck Stanton testified, he thought it was a finished house. It was A to Z. It was a turnkey house. That's how we understood it. A contractor can't be promising something he doesn't intend to deliver. If you do that, you got to be held accountable. The Stantons just wanted their house finished in accord with the promises, and Lassonde didn't do that. The Stantons always intended to pay for the work. As the Stantons saw it, the Lassondes never returned to complete it. When a contract like this executes over a period of time and there are constant oral modifications, it's not clear when exactly the contract ends, especially when neither party is willing to state clearly that I'm not taking care of everything or I'm not going to do the soup to nuts. The end point, had Lassonde said that, would have been more definite. This was a misunderstanding that was mutually created. I want to turn now to defamation. In the context of the Stantons' circumstances, the things they said were reasonable. Look what had just happened to them. Lassonde had promised they'd be in by Thanksgiving or Christmas at the latest, and that didn't happen. There were a list of oral promises regarding specific items, some of which were not kept. Lassonde came to the house in January, supposedly to fix everything, but the Stantons got stood up. Then Lassonde sued. The Stantons were incredulous at this because they felt they were the ones who had been wronged. On top of all this, a month or so later, some yucky stuff starts growing in the Stanton's house. The Stantons don't know what it is. He's not a microbiologist, but it looks like mold and it smells like mold. And his wife is getting sick from it. So he hires a bevy of experts, and two of them say mold, and two of them say the only way to fix it for sure is to destroy the house. So regardless of whether those experts' evidence is admissible, it formed the basis for Stanton's reasonable belief. So from Stanton's point of view, not only did Lassonde not keep his promises, he built a sick house too. So Stanton went around town, and it's not the way you or I might handle it, but Stanton's went around town telling people it was a bad build and that the only way to fix the house was to destroy it. He was telling the truth as he reasonably saw it. Malice is reckless disregard of the truth or knowingly disregarding it. But Stanton's had reasonable information, and so was not malicious. Finally, there's this issue of attorney's fees. The contract says fees are for filing a lien in the registry of deeds. It mentions fees for mechanics lien and for filing in the registry, but it doesn't mention fees for litigation in court or collection. And even if it did, it's ambiguous regarding what type of fees and costs are meant by the clause. So therefore, the court properly didn't award them. If there's no questions, I'll sit down.
Counsel, my question, looking at the language on the legal fees, contractor reserves the right to file a mechanical lien or a lien certificate with the registry of deeds for any portion of the unpaid balance. I assume that means on the contract. You have that in front of you?
Thought I had it here.
I'm looking at the court's order on the motion for clarification, which,
Yes, and what's the question? I'm sorry.
okay. So it says, the contractor reserves the right to file a mechanical lien or a lien certificate with the Registry of Deeds for any portion of the unpaid balance of what? The contract?
Yes, I think that's
Okay.
for the, right, the unpaid balance of the contract.
Plus collection costs, interest, and attorney's fees. What attorney's fees?
Presumably for filing in the Registry of Deeds. I mean, that's what the contract says.
So you file in the Registry of Deeds for the unpaid balance of the contract, and you're entitled to any attorney's fees associated with the filing.
With the filing in the Registry of Deeds.
Right.
Now, my opponent would like to take that clause and say, well, that really means enforcing the
Well, it's-
lien, but that's not what the
What are the
clause says.
collection costs?
They don't, so it doesn't say
Well,
collection costs.
what do you reasonably interpret them to be? Collection costs of recovering the unpaid balance on the contract, or collection costs associated with mechanics lien?
I think the mechanics lien, I mean, that's what the clause
collection-
says.
What collection costs are there on a mechanics lien?
Probably not very much.
So maybe we should read the contract more sensibly to say collection costs on the unpaid balance of the contract.
But that's not what the parties signed to.
I'm sorry?
But that's not what the parties agreed to when they signed the contract. You know, I don't think there's any call here for reformation of the contract more generally. The parties contracted for attorney's fees for filing in the Registry of Deeds, not for collection fees in this lawsuit more generally. Thank you.
Thank you.
I think I'm all set, Your Honor.
Great, thank
Thank
you
you.
very much. Case submitted.